Good afternoon, everyone. My name is Alexis Alvarez. I'm the Director of Statewide Training at Florida Legal Services. And it's my absolute pleasure to be here today with Professor Robert Bonner at Barry University, who is going to teach us all about social media evidence, how to get it, and how to use it. So before I go into the housekeeping announcements, I just want to say I remember when I was in litigation, and I remember social media evidence. And I remember all the juicy stuff that you could get on that social media. And I remember saying to myself, what are the rules that govern this? Is it different than, regular evidence? Is it different than regular discovery? What can I do to get it? And then how do I actually use it when I'm in trial? So I know that I've had those thoughts throughout my time in litigation. So I'm sure all of you on here have too. So I say that to say I'm incredibly excited, not only for our awesome speaker today, but also to really delve into this topic. So before we get into all the content and introductions, I want to go over some housekeeping announcements as always. So first and foremost, this is being recorded, and a copy of the recording will be sent to all of you who are here today and anyone who registered. So don't worry if you have to hop off, if you have to, put out one of those fires that you're always doing, in your job. Don't worry, you will still get a copy of the recording, even if you have to hop off early. Second piece of housekeeping announcements is that this was approved for CLE credit. I'm always trying to get you your CLEs, and this particular training is going to get you technology and general CLEs. So for those of you who are dying to get those tech CLEs and need them to get through a cycle, I'm glad you're here because we're going to get you through it and get you those credits. Third piece of housekeeping announcements, questions and answers. Please feel free to chime in. Give us your thoughts, give us your questions. Don't be shy. I know it's the virtual world. I know that makes it hard to connect, but I'm here for you. Professor Bonner's here for you, and we really want to hear your questions and thoughts. So with that being said, feel free to put them into the chat or the Q&A. I will be monitoring those questions, and I will present them to Professor Bonner as we go through the presentation. So when they come to your mind, drop them in. And the last piece of housekeeping announcements I think I'll say is closed captions. I actually did forget to enable the closed captions. I'm going to do that right now. And so if folks do need that extra accommodation, you should be able to click the show captions somewhere on your Zoom, and that will get you the accommodation that you need. If you need extra accommodation or have any questions or want to talk offline, I'm going to drop my email address into the chat. That way, if you need anything, don't even hesitate to reach out. I am here for you all always. And with that being said, I'm going to turn it over to Professor Bonner. And before I do that, I want to say some of you might remember him when we did our trial skill technology training. I think that was back in February. This presentation piece of that training was so good that I begged him to come back. And I will say I didn't have to beg him that hard. He is a good friend to legal aid and always willing to help us out. So for those of you who attended that, this is going to be the full version that you didn't get during that training, but you get now. So with that being said, Professor Bonner, thank you so much for being here. Thank you for all that you do to participate in our training initiative and teach our legal aid community. The floor is yours for some introductions and to move into the content here today.
Well, thank you. It's my pleasure to be able to help out. I am not a career academician. I'm an assistant professor here at Barry, but I've only been a full-time professor for a year. Before that, I was a trial lawyer for 41 years, doing civil trial. I was board certified for over 30 years. And so I made a career out of trying cases. We did not have social media when I started as a lawyer back in 1981. But when social media kicked in during this century, it became a great source of information, a great source of evidence. So hopefully I'll be able to share some things with you this afternoon that you'll be able to use in your practices moving forward. And of course, when can we click? There we go. So I'm a big fan of great witticisms, and Ron White, who's a comedian, said, "You can't fix stupid." And the universal truth is that people everywhere do stupid things. They do stupid things that damage their lawsuits. They do stupid things that damage their lives. But the 21st century universal truth is people feel compelled to post the stupid things that they do on the internet. For God knows what reasons, they want to share their stupidity with the world. And we have seen example after example of that in life in general and in litigation in particular. So Facebook is the big granddaddy of the social media. It is an online social networking service. As of a year ago, there were nearly 3 billion monthly active users on Facebook. Now, Twitter, although Elon Musk seems convinced that he wants to burn this to the ground, Twitter is also a very popular social media site. It is an online social networking service. It lets its users send and read short 280 character messages called tweets. As of July 2022, there were 238 million daily active Twitter users. That's probably a lot less now, but that's quite a bit. So then we got Instagram. Instagram, I believe, is part of the Facebook family. Online photo sharing, video sharing, social networking service lets the users take pictures and videos, show them on a variety of social networking platforms. In 2022, there were 1.28 billion Instagram users. TikTok. Everybody's got their own opinion about TikTok. Some people get all wound up about it and say it is evil and try to ban it, but it's a very popular social media platform. It is a short form video hosting service. TikTok hosts user submitted videos. They can be from 15 seconds to 10 minutes in length. And as of 2022, it was estimated TikTok had 80 million active monthly users here in the United States. So you have a variety of places where people can post all kinds of things that can be damaging to them when they're involved in litigation. So social media posts can be relevant and material to the claims that are made in litigation. Several years ago, there was a football player at the University of Florida who was involved in a domestic violence situation, and he made the mistake of sending a online tweet or message regarding his girlfriend, in which he said, "Time to die." Obviously, that was something that would be relevant with respect to getting an injunction for protection against domestic violence. So social media posts can be relevant and they can be material because people post content that is adverse to their interests. But how are you going to find it? How are you going to get it once you found it? The key is to find it and to obtain it. Now, the Florida Bar actually has an ethics opinion that deals with certain aspects of social media evidence. In ethics opinion 14.1 in June of 2015, there were 4 questions that were asked. Number 1, pre-litigation, may a lawyer advise a client to remove posts, photos, videos, and information from social media pages and accounts that are directly related to the incident for which the lawyer is retained? Second question, pre-litigation, may a lawyer advise a client to remove posts, photos, videos from the social media pages and accounts that are not related directly to the incident for which the lawyer is obtained? Number 3, pre-litigation, may a lawyer advise a client to change social media pages, accounts, and privacy settings to remove the pages and accounts from public view? Number 4, pre-litigation, must a lawyer advise a client not to remove posts, photos, videos, information, whether or not directly related to the litigation, if the lawyer has advised the client to set privacy settings to not allow public access? So 4 questions here because lawyers don't want their clients' social media posts to come back and bite them during the litigation. Much to my surprise, the bar said the inquirer may advise the client to change privacy settings on the social media pages so they are not publicly accessible. The bar also said, provided there is no violation of the rules or substantive law pertaining to preservation and/or spoliation of evidence, the inquirer may advise that a client remove information relevant to the foreseeable proceeding from social media pages so long as the social media information or data is preserved. Now, personally, myself, as someone who was a trial lawyer for 41 years, I am very uncomfortable with that last part. What I advised my clients when I was practicing was to set the settings to private, the privacy settings, not public, but private, and to just simply stop posting on social media. Don't do that anymore. Give up your addiction to post every waking moment of your life on social media. But I also told them you need to preserve and retain all data stored on your computers. You need to preserve and retain data on your mobile devices, online storage devices to relate to the categories of information. I would send a letter to them, a retention letter, telling them what they had to keep and asking them to acknowledge it and sign it and to confirm that they were going to do it. Preserve and retain email messages, text messages, metadata, message contents, attachment, links, logs of system usage, etc. Do not delete this because I did not want to get dinged with spoliation of evidence. I would also tell them that this meant do not delete any social media posts, emails, or text messages. Don't be deleting that stuff because spoliation is something that's going to come down on you like a hammer if you do. I would tell them do not destroy or dispose of any laptops, smartphones, tablets, or other electronic devices. Don't do that. It can come back and bite you. I did not want to be the lawyer who would end up in a published opinion as a cautionary tale about spoliation of evidence. That is the last thing you want to do with your career, is end up being dragged through the court of public opinion as well as through the Florida bar proceedings and any other legal proceeding because you were involved in spoliation of evidence. Now, that being said, I'm aware of lawyers who do the exact opposite. There is a certain law firm that has a very public presence in the state of Florida and may be the largest personal injury firm in the United States, if you know who I'm referring to. And when I had a dispute with my homeowner's carrier, I retained them to deal with my roofing claim. And I got a contract which included a separate social media provision, a separate document on social media that told me to delete my social media postings, did not have anything in there about preserving the social media, and to set anything I have that might be kicking around left over to private. So I was not comfortable with that. And I was very happy when my homeowner's carrier surrendered without having to litigate because I did not want to be going down that road. So don't do that. Do not delete. Do not tell your clients to delete. It's just going to be a very unhappy ending for you if you do. So what do you want to do in the way of pre-litigation investigation or informal discovery to find out what type of social media the opposing party may have? Now, if your client knows the adverse party, then your client's going to be a great source of that information because your client will probably know if the adverse party has Facebook, Twitter, has Instagram, has TikTok, or any of the other dozens of social media accounts that exist out there. Your client could be a good source for that. Your client could probably tell you the social media handle that this person has, and it can help you get this information. But if your client doesn't have that information, there are other ways to get it. And the first one is Google. I always tell lawyers, Google is your friend. You can find just about anything in the world off of Google. Do not be afraid to do a pre-suit Google search for the adverse party's social media accounts. Plug in the person's name and then plug in Facebook after the name, or Twitter, or Instagram, or TikTok, or any other social media account, of which God knows there's dozens, if not hundreds out there, and you can probably use Google to find their account, because so many people have their account settings on public, which lets anyone view their contents. If they're public, anyone can view. So even if the settings aren't public, you can at least learn of their existence by doing a Google search. What should you do then? Well, save a screen capture of the social media accounts. Print screen, save, PDF. Why do you want to do that? Well, because they may get the letter from their lawyer telling them to delete everything. And this would be a good way to deal with a spoliation claim, to do a setup. What else should you do when you become involved in a case where there is potential social media evidence? Send preservation letters to opposing counsel requesting preservation of not just the accounts, but all of their content. You can probably find good preservation letters online just by doing another Google search on that. If you want a form of a preservation letter and Google can't help you, send me an email. My email address is rbonner, BONNER, @berry.edu. So you can find me here. I'd be happy to share with you the preservation letters that I would send out. So when you send out a preservation letter, what should you ask for? Well, you want to ask for preservation of any and all social media accounts, including Facebook, MySpace, if that still exists, Twitter, Instagram, Vine, Tumblr, Flickr, maintained by or on behalf of the claimant. And again, the list is actually longer. I know the last year I practiced, I had gone online to do some searches on what types of social media accounts were out there, and there were probably 30 or 40 different types of accounts that I put into my preservation letter. Request opposing counsel to preserve and retain all data on the opposing party's computers, mobile devices, online storage devices like cloud devices that relate to the social media accounts. Request a full backup or snapshot of the accounts be created immediately. They can do this. It is possible. Request it, demand it. Remind opposing counsel of the duty to maintain, preserve, retain, protect, and not destroy any of the documents or data, both electronic data and hard copies that may be relevant to the claims. Remind them of this obligation. Advise opposing counsel that if they don't preserve and retain the electronic data and evidence, it could be spoliation, which will subject counsel and his client, her client, to sanctions. So make sure you do this. What if the settings are private? Well, here's what you don't want to do. Never, ever, ever ask to friend the opposing party. That is dead smack wrong and a violation of ethics. Florida Bar Rule 4-4.2, communication with person represented by counsel. A lawyer must not, that's mandatory, communicate about the subject of the representation with the person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer. So that's your first thou shalt not. And then you go to the next thou shalt not. 4-4.1, truthfulness in statements to others. Now, this rule does not have a Florida Bar opinion on it, but There is a Philadelphia Professional Guidance Committee opinion from 2009 in which the issue was brought up whether it was ethical for a lawyer to use a third party. Let's get your paralegal. Let's get your assistant. Let's get your investigator. Or let's get your wife or your husband to friend the witness or the party. The answer is no, you can't do that. That's a big negative. Deception is deception. So you have to use honesty in dealing with people, and finding some shady way to get access to someone's social media by sending a friend request is not a way to do it. So don't be doing that. Any questions so far?
None so far.
Okay, very good. And we will move ahead. So let's talk about formal discovery. What types of formal discovery can you as lawyers do to get social media information? Well, the bad news is social media accounts are not subject to subpoenas. The Stored Communications Act, 18 U.S.C. sections 2701 through 2712, creates a Fourth Amendment-like privacy protection for email and other digital communications stored on the internet. Now, this applies to internet service providers. This applies to the social media companies. It limits the ability of ISPs to reveal content information to non-government entities. It limits the ability of commercial ISPs to do this and to comply with a subpoena. They don't have to. In fact, they are forbidden to divulge to any person or entity the contents of any communication which is carried or maintained on that service. Now, what can an ISP do? An ISP can disclose the contents of the subscriber's communications if authorized by the subscriber. So if you can get an authorization, either by saying, please, or by getting the court to order the opposing party to give you an authorization, you can get the contents from the ISP. Pursuant to the Stored Communications Act, they cannot disclose non-public contents without the user's consent. So courts have a very, very restricted view with respect to social media discovery. They are wary of what they call fishing expeditions under the guise of discovery requests. So when you are doing social media discovery, you have to craft it in a way that is narrowly tailored to the facts of your case. Go to the case of Root versus Balfour Beatty Construction, Florida case in 2014 that addressed the issue of the nature of a discovery request for social media information and the need to tailor it. In that case, a young child was injured playing outside a construction site. The mom filed suit on behalf of the injured child. Defendant requested social media account information from the mother. The trial court entered an order compelling discovery of the requested social media account information. But the appellate court reversed. And although they reversed, they said, hey, this information may be discoverable under the proper circumstances. However, the discovery in this case did not relate to the accident, did not relate to the affirmative defenses, did not relate to the mother's claim for loss of consortium of the child, but was just a fishing expedition, dredging for information. And they said, what you need to do is you need to tailor it. The discovery should have been limited to the impact of the child's injury on the mother. You need to focus this on the issues in the case. You can't just say, I want the contents of your entire Facebook. I want every Twitter post you've made in the last 5 years. You have to specifically tailor it to the facts of the case. So then we had case from the Middle District of Florida, Palma v. Metro PCS Wireless. And that was a Fair Labor Standards Act case brought by employees of Metro PCS seeking unpaid overtime wages. The defendant launched into a broad request for social media discovery. In that regard, they asked for all posts to the social media accounts from 2010 to the present that relate to any job descriptions or similar statements about this case or job duties and responsibilities or hours worked, which plaintiffs posted on LinkedIn, Facebook, or other social media sites. In support of this, defendants said the information is relevant to the affirmative defenses that the plaintiffs were not entitled to overtime because they were exempt and because the posts are party admissions regarding job duties, responsibilities, or hours worked, which were the issues to be litigated in the case. So they've got a good plan here going in by the way they've described the information they're requesting. They also said that the plaintiffs may have posted comments that contradicted their testimony in the case about their breaks they received or the hours they worked. The plaintiffs' counsel objected, said, this request is overbroad. You can't have it. It is too broad. It's not specifically targeted for the right information. The court agreed and sustained the objection. Now, this was much more narrowly drawn than in the Balfour case, but the court says, hey, social media content is not privileged or protected by any right of privacy. If you send out discovery for social media information, there are some boilerplate objections you're going to get. You're going to get objections that it's protected by the Stored Communications Act, which if you were requesting it from social media company like Twitter or Facebook would be true, but it is not protected by the SCA if you're requesting it directly from the individual who has the account. So that is the first nonsense objection you're going to get. And you're also going to get a right to privacy objection. Again, that is a nonsense objection, and these cases on this slide support that proposition. But you don't have a generalized right to just dredge through information that the plaintiff has limited from public view. So you have to tailor your discovery request to that which is reasonably calculated to lead to the discovery of admissible evidence. That is the standard under Federal Rule 26. That is the standard that you all know under Rule 1.280 of the Florida Rules of Civil Procedure. Discovery has to be reasonably calculated to lead to the discovery of admissible evidence. Now, much to my surprise, the court felt that the defendant had not done so with this social media request. I thought it was a lot more narrow than Balfour. Apparently, this court did not feel it was narrow enough. So then we go on to Salvato versus Miley, which is Middle District of Florida, 2013. In that case, there was another request for social media discovery. And there really wasn't much to support the request for it other than, well, it might have something in there that is a party admission that would be helpful for us in our case. But they didn't have any specific targets. They didn't have any basis for that. It's just, well, it could be, it might be, we don't know. Speculation is not enough. Speculation is not a sufficient reason for the court to compel production of this social media discovery. You got to have more. Where do we go from there? It's not always bad news. Davenport versus State Farm, that particular case, there was a discovery request by State Farm in a personal injury action, and they had requested certain tagged Facebook photos of the plaintiff participating in physical activities. And the court granted the motion to compel because the plaintiff's physical condition was an issue. You know, I can't do this, I can't do that, I can't do any of the things I could before. Well, we would like photographs in which the plaintiff was tagged, in which he's participating in the following activities. The court says, yeah, we're going to allow that discovery. Then we go to the case of Higgins versus Coke Development Company. In that case, the plaintiff said, once again, my injuries have impacted my ability to enjoy life, engage in outdoor activities, and find jobs. Specifically targeted social media request. The court said social media under those circumstances was discoverable. Then you go to Romano versus Steele case, New York. In that case, once again, social media is discoverable where the plaintiff had placed physical and emotional condition at issue. So if you want to avoid the omnipresent fishing expedition objection, be prepared to show the relevancy of your discovery request. Make your social media discovery request specific. Now, you may have a case where there are allegations of domestic abuse. In those cases, target it to social media posts in which opposing party has made comments directed to your client. Social media posts in which your client has threatened your client. Social media posts in which your opposing party has bragged about putting a whooping on your client. All of these things, specifically target them in your social media discovery requests so you can use them. Make your discovery requests as specific as possible. And not just with respect to the activities that you're trying to document. Limit the time frame of your social media requests. They are not going to give you the social media content. The court, is not going to give you social media content from the beginning of their social media account to the present. You need to limit the time frame to make it relevant. Tailor your social media discovery requests to the specific facts and issues of your specific case. Make it something that is targeted, that is laser focused on what you want and what is relevant to your case. Now, as I said, you cannot send subpoenas. Well, you can't successfully send a subpoena to Facebook or Twitter. You can send them subpoenas all day long. And once they finish laughing, they'll send you a nice little letter saying, we don't have to comply because of the Stored Communications Act. But you can get the court to compel your opposing party to execute an authorization to obtain social media account information. Beswick versus Northwest Medical Center, a case out of Broward County Circuit Court in 2011, which actually required a party to execute a release. So what do you want to get? You want to get the activity log from the social media provider. What is the activity log? Activity log includes a timeline of the user's information, a timeline of their posts, their messages, their photos, and much more. These are things you want to get. So, any questions about that?
None that I see in the chat so far.
Okay. Everybody must be multitasking. So let's say you've got the social media information. What are you going to do now? Once you get the social media information, how do you use it? Because although it may be fun, it may be interesting, it may be entertaining for you, it may be something that causes your blood to boil because it is so hateful. If you can't get it into evidence, it's just another useless bit of digital information. So you have to get this into evidence in order to have it make an impact on your case. So there is no provision in the Florida Evidence Code on admissibility of social media evidence. None whatsoever. It'd be nice if there was a rule that said social media evidence and told you how to get it in. It's not there. Likewise, it's not in the federal rules of evidence either. But what you have to do is look at the basic principles that apply to all evidence. So what is the first place you want to go with respect to your evidence? Well, number one, it has to be relevant. Has to be relevant and material to the issue to be tried. Now, if you have directed your discovery requests in a focused manner, it should be relevant and material to the issue to be tried, but you have to be prepared to argue that to the court. The biggest problem you're going to have is authenticity. You have to find a way to authenticate the evidence you get. Now, you may be lucky and the adverse party may be willing to concede that it is their social media account and that they made the post. I had one of my, students come to me a couple of weeks ago who recently graduated and explained that she had a social media problem. She remembered we talked about this in class and wanted to know, again, the steps on getting it into evidence. And I said, well, first you have to make sure it's relevant, and then you have to establish its authenticity. How are you going to do that? There is no textbook or guidebook on authenticating social media evidence. But if you go to the evidence code, go to 90.901. 90.901 gives us some basics on authentication of evidence. Requirement of authentication or identification. Authentication or identification of evidence is required as a condition preceding to its admissibility. So you have to be able to authenticate or it's not going to go into evidence. What do we do there? The requirements of this section are satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. That means that you have to convince the court that you have enough evidence that this post on social media, ostensibly made by the adverse party, is what you claim it is. It's not something that you cooked up on a Photoshop or something like that. It is something that is real. It is something that's legitimate. It is something that was posted by the opposing party or on the opposing party's behalf. Now, major concerns about social media is that there is a lot of uncertainty that the post is what it purports to be. Who had access to the account? Who could have posted the account? And what if they're posting under something that's not their real name? They've got some stupid screen name. So there's where the concerns are. The concerns stem from anonymity and fraudulent presentation of identity that are there on the internet. There are parody accounts. There are people that post under other people's names. So this is a hurdle you have to get over. So what is your first question? Was the post made by the litigant? Was the post made by the adverse party? How are you going to do this? How are you going to establish this? Well, number one, does the adverse party have a social media account? Your client may know this. The adverse party may admit to it. So do they have a Facebook account? Do they have a Twitter account, a TikTok account, Instagram, whatever? First question. Then, what is the adverse party's screen name or username? Again, your client may help you with this. The adverse party may admit it. You may learn this in a deposition. Then, is there anyone other than the adverse party who is authorized to post on the account? Has anyone other than the adverse party ever posted on the account? Has the account ever been hacked? Have you always reported hacks and removed unauthorized posts? Yeah, we see it all the time. You see people posting stupid things on social media, people in politics, people in business. Usually there's some sort of maybe alcohol or drugs involved when they make the stupid posts. And the go-to move is, my account was hacked. Really? Did you report it as being hacked? Did you ask them to remove the unauthorized posts? These are questions. This last series of questions, when you are taking an adverse party's deposition, ask them all of these questions, because you need to know the answers to these questions, because it's going to help you lay a foundation for getting the social media evidence before the finder of fact. So again, how are you going to do this? Well, testimony of a witness with personal knowledge. It could be your client. It could be the adverse party. Sometimes they're photographs. Is it a photograph of the adverse party? Okay. What if it is a photograph of them? Was it taken by them? Was it posted by them? Was it posted with their knowledge and consent? These are all things that you want to know. Again, you can find this out in discovery if you take depositions. But let's say you're not able to get this in a deposition. Or let's say you get to the deposition, nope, I've never had any social media account, never had a Facebook, never had a Twitter, never had a TikTok, never had an Instagram, never had any Truth Social, any of these social media accounts. But your Google search has shown that they do have these social media accounts. Where do you go from there? How do you move forward at that point when they're denying everything? Well, again, your client might be able to help you, might not, we don't know. But how about using a third-party vendor or an expert to help you with this? There are third-party vendors out there that do nothing but social media research, social media discovery, social media investigation. And there would be times when I would retain a third-party vendor to go out and do a social media search of the adverse party, and they would come back with all kinds of information. And they would somehow work their magic and download photographs and posts and everything else. And you would be able to use this vendor to get the information into evidence. They would tell the court what they did. They would tell the court how they located the information. They would tell the court how they verified the information. They would tell the court how they downloaded the information, and they were able to determine when the information was uploaded to social media, where it was uploaded from. Some of these photographs, most of these photographs you see uploaded to social media, they have tags on them. You may not know it, but there are tags in the metadata of these photographs that show you when the photograph was taken, when it was uploaded, and also from a geospatial standpoint, where the photograph was taken. It's incredible the amount of data that is in these photographs. So there are third-party vendors out there that can help you with this. They are not cheap, but they are money well spent if you can't get it anywhere else. Any questions about third-party vendors?
I don't see any right now.
Okay. I have numbed them all into a state of slumber. Okay, some takeaways here. Number one, have a witness or several witnesses who can ID the social media evidence. Number two, establish the relevance of the evidence through testimony. Number three, request that the witness identify the item. Number four, establish the authenticity through the witnesses. Number five, establish the evidence is a true, accurate, and unedited depiction of what it represents. Next, offer it into evidence. I was telling my trial advocacy students the other day, offering something into evidence isn't rocket science. Let me show you what's been marked for identification as Exhibit A. Do you recognize it? What is it? How do you know that's what it is? Your Honor, I offer Exhibit A into evidence. Boom, done. Then If there's an objection as to lack of foundation, do some more voir dire as to the foundation. Lay as much foundation as possible, but it should not be hard to get it into evidence if you establish its relevance, establish its authenticity, and that they recognize what it is and they know what it is. So it should not be a problem. Okay. So questions. We hammered through this in record time.
Yes, we did, but that's because you are amazing. I will say that through the chat, some folks did say, we are here listening intently. This is very informative. Every time I think of a question, you already answer it before I can even type it in. So that's a wonderful compliment. Thank you
Thank
so
you
much.
very much.
Yeah.
Glad to be of help.
And then another one, you've anticipated all of our questions. So thank you for walking us through it. So 2 questions did come in.
Okay.
The first one I see here is, do you recommend any third-party vendors? Are there any third-party vendors that you've worked with and feel comfortable recommending?
Command Investigations is who I've used in the past.
Command Investigations. All right. The second question is also about the third-party vendors. Do you qualify the third-party vendors as experts? That's a good question.
I don't think it's expert testimony because they're more of a fact witness. They're telling about what they did. If you needed to dig down really deep and get into things like IP addresses, where the information was posted from, you would probably have to qualify them as an expert then. But if it's just, I sifted through gazillion gigabytes of social media data and was able to find these accounts belonging to adverse party, but it's only when you get to the hyper technical aspects as to the IP addresses and the tags on the information where you might need someone who's an expert.
The next question that I have that came through is, can you give us the citation for the Breswick case that you mentioned?
I can.
While you look that up, I'm going to take the screen share down so it's just us compared.
Okay, thank you.
You're very welcome. Perfect. Now it should just be the 2 of us.
All righty. Well, let me look up Breswick.
And while you're looking that up, I'll do what I can to drop the CLE code into the chat and all of that. Again, I usually have that teed up ready to go, but I also was listening very intently. So this was a wonderful presentation, Professor Bonner, and you're such a pleasure to work with. I really appreciate the way that you present and all the content that you give, especially how your presentations are so focused on, the black letter law, but also so focused on, practically how do we do this? So I think you're very unique in that sense.
Well, try cases long enough, then eventually you'll get the hang of something.
Right. And also when you're a litigator, you know how to fill up space with talking, right?
Actually, I think what I try to tell my students is less is more.
Well, always. And the first judge that I ever worked for when I was, I guess I was a certified legal intern or something like that, said the best litigators slow things down.
Okay, the case of Beswick, the Northwest Medical Center et al. It's case number 07-020592 from the 17th Judicial Circuit, Broward County, Florida, November 3, 2011. You probably have to find that in the Florida Law Weekly SUP that handles the circuit court orders, or you could go onto the online docket system for Broward County Court and maybe pull a copy of the order there.
I will try my best to do that for folks. And Professor Bonner, lift your camera up a little bit more.
Oh, sorry about that.
Okay.
I had to look at the screen to see the Beswick case.
Problem. So what I will do, folks, is I will try to get that for you. I did, as Professor Bonner was speaking, I did type it into the chat. But I will try to get a copy of that and include that with some follow-up materials. And speaking about follow-up materials, there were some questions about whether or not folks would be able to get a copy of your PowerPoint. Is that something that you're okay with, or that you
No, absolutely. Do you have a copy, or do you want me to send it to you and you can distribute it?
If you could resend it again, just to make sure I have the most updated or anything like that, I would appreciate
Yeah,
it.
I mean, there's no pride of authorship there, and they're welcome to have it and do whatever they want with it.
Fantastic. And so I think we hit all of the questions that were in the chat. If anybody wants to put any last minute questions in, please feel free. In the meantime, I will discuss the CLE credit that you all are receiving. The CLE code is 230727, N as in Nancy. And this does qualify you for, let me look at it again, one general CLE and one technology CLE. As always, if you didn't jot it down or are looking for the information, you will receive an email from Zoom within 24 hours of this event with the recording, with the CLE information, and you can always email me. And so another question did come in to the
Okay.
chat. Is there any difference with the disappearing apps like Snapchat? That's a great question too. How do you deal with that? What do you do anything differently?
And I'm going to be honest and say I've got no idea.
There you go. Honesty is the best policy.
I think that's why my kids used Snapchat, so I couldn't check what they were doing. But
listen, I don't even know how to use Snapchat, but that is a really good question and definitely some food for thought. All right. So through the chat, you're getting lots of thank yous. Thank you. Thank you. Very informative.
you're welcome.
Well, Professor Bonner, this is the second time that I've had the absolute pleasure of working with you in our statewide training initiative. I hope that I get another chance, moving forward, because it really is wonderful to learn from you. And on behalf of the legal aid community and our statewide training initiative, I can't thank you enough for being here, for teaching us, and really just giving us some of your time today.
Hey, I'm always glad to help and speak on this or any number of other topics.
Awesome. Well, you heard everybody. So if anybody has any other topics they want to hear about, seasoned litigator just offered to come back. So if you have any ideas, feel free to reach out to me. You all have my email address. I like to make the trainings that you need happen. So let me know what you're looking for.
Seasoned is a polite word for old.
I'm not that polite. No, but thank you, Professor Bonner.
You're quite welcome.
Have a wonderful rest of your day. And thank
Okay.
you everybody for being here.
And I just sent you the PowerPoint.
You rock.
Okay.
All right, everybody. Have a good one. See you at the next training.
Take care. Bye-bye.
Bye.